sector.
Thank you. It's a little bit after 5. I want to be respectful of everyone's time, and I definitely want to get to public comment in a bit, but I wanted to ask one more question before getting to public comment. Both of you have talked about the PUC as an institution, and the current regime at the PUC is doing some things right. I represent a district that has a number of cities that have had accountability issues. Folks have heard me talk about this. I represent 9 cities. 5 of them have former council members in prison. This stuff strikes close to home. I see in the cities that I represent sort of the new administrations, new generations of council members who are exceptionally well-meaning and trying hard, but have inherited a mess in a lot of those instances. This gets to the PUC. It's analogous to the PUC in that we get to the question of the environment and of the culture. And so I wanted to get both of your takes on, since you've sort of been inside the PUC to conduct these reports, the extent to which the reforms that we mandate here, the extent to which they can influence the culture of the PUC.
Yeah. We all know that there are limits to what you can do about a culture, but the culture evolves in its own petri dish, and you get to define the metes and bounds of that petri dish. And if you require the commission to do its business in public, it has, we've seen that across the board in state government. State government is more open. And, will it prevent us from having a commissioner with a felonious intent from doing something really terrible? Probably not. It may increase the probability they'll be detected and prosecuted for it, and that may deter them. But ultimately, the question isn't, can we turn this agency into a place where nothing will ever go wrong? No, but we can do so much. You can do so much to create an environment in which everybody, out of self-interest, will do the right thing.
Yeah, I think I kind of agree with that. You've got to set the framework, but then the PUC has a lot of work to do to change its own culture internally. The executive director, Tim Sullivan, I think is actually doing a lot of things that I think are having very positive results in that regard. But more needs to be done, and I think some legislative guidance would be helpful.
Thank you. Thank you, all 3 of you, Ms. Palmer, Mr. Stromwasser, Mr. O'Neill. Thank you very much, not only for being here today, but for the work that you've been doing on the PUC. I want to allow for public comment. Is there anyone present who would like to address the committee? We'll use that microphone right there.
Mr. Chairman, members of the committee, I don't want to repeat any of the comments I made with regard to SB 660, but there are some things that we think are very important to emphasize. The problems that were disclosed with the ex-parte communications that became so notorious are all the result of violations of existing rules in statute and at the PUC. If those communications had been reported as they should have been, or if the commissioner had said, no, I won't take this with you because you didn't give 3 days notice to other parties, the problem would have solved itself. We think largely this is a problem of enforcement. And I'll note that since we've made our comments, and we also participated in a workshop held by OPR on this issue, the Little Hoover Commission has issued its report on open government issues, and they in fact have endorsed essentially the same position we have, which is that ex parte communications are still an important and really necessary information tool for commissioners, because most of what they do is really quasi-legislative. Both the California Supreme Court and the U.S. Supreme Court have said that rate setting is a quasi-legislative act. And so I have only the greatest respect for Mr. Stromwasser and Mr. O'Neill's efforts and the things that they presented. But if you're going to draw a line, rate setting ought to be on the quasi-legislative line, not the adjudication line. It is not like a complaint case. It's not like an enforcement case where you really don't want anybody talking to anybody. It's a policy-making case. So I did want to emphasize that. And also, I don't mean to blindside Ed, but just doing a quick calculation, in an average case at the PUC, you can have a lot more than 20 parties. In the gas accord, we had 20 parties who were really, really intense into what was going on to try and fix the PG&E system. If you had them all participate in an en banc proceeding, and you didn't give them 2 or 3 minutes, you gave them 20 minutes, that's 7 hours of hearing time for the commissioners. And if you did that in the 600 cases, the PUC decides that's 525 8-hour days crammed into a 365-day year. It's really not possible to use that kind of a mechanism to provide the additional opportunity for input if you take away ex-parte communications in general. And that's why we think it should essentially be those parties that feel they need to go to the commissioners and their advisors and to the key division directors and explain what's going on in their case. They should have the opportunity to do it, but only if everybody knows about it through reporting. Tern made the comment that you can't have these things happen in secret anymore. They're not in secret if they're properly reported, and if some of the provisions in the legislation are adopted to require very specific and definitive and comprehensive information about what was said, then everybody can respond if they feel they need to. That is a model that worked for the first 90-some-odd years of the Commission's history, and that's why we think you need to think very carefully before you just throw that out and say, well, we're going to have to come up with another system. The ones who get hurt in that are not the large utilities. Thank you.
Thank you, Mr. Day. We know, obviously, who you are, but can you identify yourself for the record?
Well, I spent 11 years at the Public Utilities Commission. I ended up being a deputy general counsel and an acting general counsel. Since that time in 91, I've represented a wide...
I was actually asking you to state your name and your affiliation.
Oh, I'm sorry.
That's okay.
I apologize.
That's fine.
Michael Day of the firm of Gooden, McBride, Square, and Day.
Thank you very much.
Thank you.
Appreciate it. Is there anyone else who wishes to address the committee? Great. Fantastic. Again, I'm sorry. Mr. White?
Mr. Chairman, members, I'm John White. I'm the director of the Center for Energy Efficiency and Renewable Technologies and also lobbyist for the Clean Power Campaign. We have followed these issues carefully, and we want to commend the committee for the depth to which it's been looking at these issues and working with your colleagues in the Senate. We also thank you for this hearing and for letting some of these recommendations be publicly discussed. I think there's a lot of really good, sensible thinking here. I think one of the things that I might agree with Mr. Day on in terms of ex parte is that you've got to find a way to balance the unequal access that is often the case for people that are participating. And yet we've also got to, I think, take advantage of public opportunities. I've lobbied and worked with a lot of different agencies, and the PUC really is more isolated and less accessible than almost any other institution in state government. And I do think it's deeply rooted in the culture and in the procedures and the practices. I think the suggestion for an en banc meeting, while there may be some cumbersomeness, just like when we had the Hells Angels up here on the helmet bill, it had too much testimony and so forth. But the idea of public meetings and public discussion so people can listen and be heard, I think, is really important right now. When there's public comment at the Commission on matters that are pending, oftentimes the public comments are lumped together as opposed to on the item that's being discussed, even for non-parties. So I think looking at other agencies' practices, and I know your staff has been doing that, I think there's lessons to be learned, but I also think that a situation really needs to change, and we need to somehow find a balance between fairness and transparency and access and reliance on the record, along with the need to not allow some parties to have more equal access. And I also think that commissioners need to show up for work. One of the things we've seen recently is commissioners are not present at the commission too much of the time. There's a lot of conferences, a lot of trips, a lot of travel. I think that at some point getting, as Mr. Strumwasser said, having more opportunity for the commission to meet in public and deliberate with each other and with the public would be a good thing. And I also think that Bagley-Keene reform is a very important part of the solution. I think the legislature sort of inadvertently made this problem worse, and then the PUC interpreted the statute to make it much more restrictive and much more impractical than the same requirements as applied in other agencies. So I think it would be good to engage the commissioners themselves in some of these discussions, as well as thank you for the opportunity to make some comments myself.
Thank you, Mr. White. Your points are well taken. We heard a little earlier during Mr. Leno's presentation of his bill, the concern that some folks have with respect to unequal access. It was an issue that arose as well during my pursuits of sort of the judicial reform aspects of the PUC. So it's something that we're certainly aware of, but we appreciate you framing it that way. I also know that, Mr. White, you asked committee staff earlier about the availability of the slides. All of the slides will be available to anybody watching, listening, or sitting here. The slides that we presented here will be available by contacting my office. We also have copies of the Strumwasser and O'Neill reports that we'd be happy to provide to you, as well as on our committee website. So thank you as well. Is there anyone else who wishes to address the committee? Great. I also wanted to thank the work of the CPUC staff. I know that some of them are here. They've been exceptionally forthcoming with respect. They've visited my office on several occasions and are providing constant updates about the efforts on behalf of staff at the CPUC. So we do appreciate them. If there's no one else who wishes to speak, this concludes the July 13th informational hearing. The hearing is now adjourned.